Okay, let's now revise the chapter of inspection, inquiry, and investigation. So, this is chapter 14 of Companies Act 2013, starting from section number 206, going till section number 229. Right? Okay. Now, basically, when we start with this particular chapter, we can see, as the heading itself suggests, that it's divided into three parts: inspection, inquiry, and investigation. These can be called as three escalating stages to discover what is actually going on in a company, or how well the company is performing. Are there any irregularities which exist in the company? Right. So, inspection, inquiry, and investigation, if we go by the general meaning, we can understand that inspection is something which is not negative. Like maybe a factory is opened and some safety officer goes to check if everything is in order or not. That is a routine inspection. I'm talking in general parlance, and we have not yet started with the chapter, right? If I talk about inquiry, inquiry is something when something bad has happened. Maybe there's an accident which has taken place in a factory, and although everything seems to be okay, but still there is an inquiry just to resolve that doubt, right? So this is something, oh my god, there's an inquiry going to go on. So it is kind of negative unless the clean report is made. An investigation means there is absolutely an allegation, a suspected violation of some law, and is always negative, no matter what the outcome is, right? Okay. Now, that is the general meaning. Now, if we talk about this particular chapter, the initial four sections that we talk about, section 206 till section 209, they actually prima facie talk about the two terms, that is inspection and inquiry. And thereafter, almost the entire chapter is dedicated to investigation. So, investigation contains a major chunk of this particular chapter, and inspection and inquiry is very short content and portion. So, what is inspection? What is inspection happening? Now, here we are obviously talking about all the white collar crimes and all that. We're not talking about and investigating into the real crimes, which, of course, the criminal procedure applies here also. That also I will tell you, especially when we talk about section 212. But broadly, we are talking about the frauds that we want to discover. We are talking about the mismanagement which might be going on in the company, the irregularities, the misfeasance because of which the company or the people are suffering losses, etc., etc. So we want to discover that. We want to find out the truth. Now, if we talk exactly according to our exam oriented revision, first section is section 206. Section 206 tells us there is a company which might have filed any document, fine, or ROC might have received any information from some other source. The document filed could be any MGT form. Maybe we have just filed the financials with ROC. Based on those financial statements, ROC just went through those documents and analyzed and scrutinized that document, and based on that, they found that here you have written some information, and in the earlier document there was some other information. Maybe they're contradicting each other, maybe there is some issue which needs to be resolved. So they want more information from you. They want more information from you. I have not yet even uttered the word inspection in the sections, right? So ROC, the company filed financials with the ROC. ROC looked at those documents and they want some more information. So they sent a written notice to the company seeking more information or explanation or any further document. Fine. Now they are sending this written notice to whom? They are sending this written notice to whom? That you have to produce such and such document within reasonable time. Fine. They are sending it to the company, and can send it to the officers, the employees. In fact, the past officers and employees will also be liable to respond. Why? Because if the information relates to some previous period, maybe somebody was the director of a company and now he has left the company. He was a director maybe in year 2025 and now he has left the company. Okay, so since he has left the company, will he still be liable to give the information that ROC needs? Yes, he will still be liable if ROC has sent a written notice to them. So they also have to furnish the information or explanation, whatever they know. Okay, so once the company or the officers, the employees, the past employees, past officers, if they have received the notice within the time, within reasonable time that's specified in the notice, they have to reply. Okay, they reply within time, great. They have taken some extension and replied with extended time, okay, still fine. No reply, then this happens. If they have replied and the ROC is satisfied, okay, because of that there was a mismatch, okay, fine, we get it, no problem, right? So ROC is kind of satisfied, there is nothing further done. If ROC is not satisfied or you have not replied properly, there is an adequate reply, or you have not replied at all, then ROC will record the reasons and give a written order to company for inspection. For inspection. So they are giving another written notice that now you produce all your books, accounts, papers, everything, and now we are going to go for inspection because there is something which is not, the documents are not actually able to satisfy us. Fine. So now the inspection will be conducted. How the inspection will be conducted, that is given in section 207. Okay. So once the inspection will be complete, you have to prepare a report and you have to submit it to central government. The report is submitted under section 208 and you will give the recommendation that we'll see in 208, and CG may also further carry out the investigation. Okay. So far, I hope you're good. So section 206 is not yet complete. We also have to read about inquiry, but section 206 prima facie tells us that when inspection is triggered. Inspection is triggered when ROC, on scrutiny of a document or of the information that they have, asks for more information and the information is not satisfactory or not filed, then ROC may proceed for inspection. That is the hierarchy. Okay, correct? Then we also have something called as inquiry. Inquiry is also there in section 206 only. Now, when can inquiry happen? If ROC has some information with them, or maybe there is any complaint, any representation made by any person, okay, made by any person that the company is doing some fraud or anything like that, okay, or if the grievances of the investors are not addressed, fine. So in these three situations, any person may give the representation or information to ROC, or ROC may have information available with them only. So based on this, if ROC is satisfied that the business is being done fraudulently, or there is non-compliance of act, or the grievances are not addressed. So in these three situations, if ROC is satisfied, then ROC will inform about the allegations to the company, give them an opportunity of being heard, and thereafter carry out inquiry. Now, who is going to do the inspection and who is going to do the inquiry, right? So it may be done by ROC or it may be done by the inspector appointed. Now, both these cases, inquiry or inspection, ROC may initiate or CG may also say that you have to do this inspection or inquiry as the case may be, and there also the inspector will be appointed and inspection or inquiry shall be carried out. So inspection can be done directly by ROC or by central government. I hope that's clear. So section 206 actually tells us in what situations inspection or inquiry is triggered and can be initiated. Once it is initiated by either ROC or inspector, the next step is how it is going to be conducted. That how is actually given in section 207. Okay, thereafter, once it is conducted, then the report shall be made, and that report is given in 208. You also have the powers of search and seizure, that's actually given in section 209. Fine. Okay. So how it is going to be conducted? Once the order of inspection and inquiry is passed, ROC or inspector, what you will do is you will call for the books and papers, and it is the duty of every director, every officer, every employee that you have to produce whatever document is asked by ROC or inspector in whatever form it is asked. Okay. And of course, give all the assistance that you can in connection with the inspection or inquiry. Fine. If you disobey, then there is imprisonment and or fine. And if orders and everything are followed, then registrar, you have certain powers. Registrar or inspector, you can say, you have certain powers. See, we also read about powers of inspector in section 217, and we also read it in under section 207. Okay, broadly the powers are same which are stated with slight differences. With slight differences, no, I would say with slight additions. So ROC, what you can do, or inspector, what you can do, when you are doing that inspection or inquiry, if nobody is listening to you and you don't have any power, like if I suddenly ask you and start questioning you, if your parents actually question you that where were you might answer that, right? Because you're scared your parents may take a step, they may snatch the phone for you from you, etc., etc. So you're little scared and you will obey them because they have certain powers. But if I am asking you where were you, out of maybe respect you will reply, but otherwise I don't have a power to do anything to you, right? Or to guide you or anything like that, right? So in that perspective you might just walk away, you might not even want to answer, right? But if I also have the power that I may take your phone, I may do this and that, then you will be scared from me also and you will do that, right? In the same manner, if ROC or inspector, if I am the ROC or inspector and carrying out that inspection or inquiry and asking from you the documents, why will you give the documents to me? What if I don't give? What will you do? Well, ROC or inspector has been conferred with the same powers as of a civil court. So if ROC or inspector has asked you to produce the documents and you do not do, it is as good as disobey of court. And you will be punished as you disobey the order of a civil court. So if you have been summoned, if you have been called by ROC or inspector, consider this as a summon of a civil court. So if you disobey the summon of a civil court, then it has consequences and penalties. Likewise, here also it will be applied because you have been got the same powers as of a civil court in respect of discovery of books, summoning and enforcing attendance, inspection of books, registers, and documents. So, insert, of course, you haven't got all the powers of civil code, but in these matters, you've got the powers of civil code first. Secondly, you can call for the books and copies. Undoubtedly, you can also make copies of the books and you can also place the identification marks before returning the books in case you have seized them. Even if you have not seized them, then also you can place identification marks. Fine. So these are your powers that you have, which are stated in section 207. And of course, penalty is stated. I'm not dealing with the penalty. Okay. Then we have section 208. Section 208 actually talks about the report. So once your inspection or inquiry is complete, you will prepare a report in writing and give it to central government. Give it to central government. Fine. Now, once you have submitted the report, although it has been delegated to RD, once you have submitted the report, what is the finding of the report? The report may say that this particular person has done something or has committed some fraud, and we recommend that this should be investigated because this might turn out to be serious. It's not very small fraud, it may turn out to be something big, right? So it may include a recommendation if that is needed for further investigation. So of course you will support why are you recommending further investigation. So if there is a need to do so, do it. Okay, so that is all about the report. Fine. Now, inspection and inquiry. During that inspection or inquiry, you have a reasonable ground to believe, okay, I am carrying out the inspection and I'm continuously asking for the documents. I have found something. I have found that this particular director has been continuously involved in embezzlement or taking funds of the company, misappropriating the funds of the company. And now I ask for those documents from that director. The director will now be like, oh my God, looks like they have found out and now they're collecting the evidence and the proof. I need to tamper this proof, right? So they may do that Like they may change it, they may alter it, they may falsify it, they may destroy it, they may mutilate it, they may hide it, right? So if ROC or inspector has reasonable ground to believe that the documents relating to the company, KMP, director, auditor, CS, whatever it is, they are likely to be destroyed or done this way. They may, after obtaining special court's permission, this is very important. Often this is asked that, okay, they entered into the premises and they seized the books without obtaining special court's permission. So often in the case studies, this particular point is incorporated. Even in MCQs, it is asked that whose permission they have to take. So this point is extremely important from exam perspective. So ROC or inspector, you have to take special court's permission, and thereafter you can enter into the places wherever permission you have taken. You enter into the places, search the documents, seize them, that is taken to your custody. Okay, you prepare a list. Ideally, you tell them that these are the documents that we're taking along. The company has every right to take copies of those documents at their cost, and thereafter you can take these documents with you. Once you're done with the checking, you can also place identification marks, but you have to return the documents within 180 days. They can be called for a further period of 180 days if need be, but prima facie it has to be returned within 180 days. Fine. And before returning, again, you can make copies if you want to. Okay. So I hope that's clear. So that is about inspection, inquiry. And now we move to investigation. Now, when I talk about investigation, we have so many sections of investigation. We talk about section 210, investigation into affairs of the company. Then we talk about section 213, where again investigation into affairs only, but through NCLT. Then we have investigation into affairs by SFIO, that we read in section 212. We have investigation into ownership, that's section 216. And we also have investigation into the related entities, that we talk in section 219. So we have these many sections which we talk about investigation and which we have to read, right? So we'll start one by one. First of all, investigation into affairs. So we have prima facie 3 sections of investigation into affairs. One is section 210, second is section 213, and the third one is 212, where the investigation is not done by a normal inspector, but it's handed over to SFIO. Just like there is a crime which has happened, it may be investigated by normal police department, right? It may be handed over to some specialized agencies, maybe CBI and all that, right? If there is something big that's happening or bigger crime that's happening. Likewise, in company frauds, if there are normal frauds or normal investigation that needs to be carried out, it will be done by the inspector who's appointed. Sometimes when the frauds are serious, then it will be assigned to SFIO. That is Serious Fraud Investigation Office, that we read under section 212. Okay. So first of all, section 210. Central government, if you feel that yes, it is necessary to investigate, you may pass an order of investigation. Okay, you may pass an order of investigation when inspection or inquiry or both happened and there is a report under section 208 which is submitted, and based on that report maybe there is a recommendation that investigation should be done, and in your opinion you consider it necessary, you may order investigation. You may not. Okay. Then on receipt of SR by company, that means the company's members have resolved and they have passed a resolution that they feel that maybe there is some fraud going on in the company and they want you to pass an order of investigation. So you may, in public interest, you may. Okay. And lastly, if NCLT or court passes an order, then you must order investigation. So in these 3 cases, you may, but there is a mandatory order of investigation by CG if the court or NCLT has passed an order of investigation. Correct? Okay. Now we have section 213, where NCLT is involved. So NCLT on the application of members or on the application of any other person, you may pass an order of investigation, and in that situation you will not carry out investigation, you will tell CG to carry out investigation, and CG must carry out the investigation. Okay, so section 210 I already told you, and let's come to section 213. Fine. Now, in section 213, people are actually approaching NCLT. That if I tell NCLT and if NCLT passes the order of investigation, then CG can't deny it and CG will do it, right? Okay. So, as members, to go to central government, see, you have two choices. One, pass SR and go to central government. Central government may order investigation, or else, if you are at least 100 members or members with 10% voting power, and you have proper evidences and documents, you can make an application to NCLT. And if NCLT is satisfied of certain things, NCLT may decide about investigation, and then CG is bound to order investigation and carry out the same. Got it? Okay. So members, if your company has share capital, then these many members. If your company does not have share capital, then 1/5 of the members. They become the eligible members. NCLT. Members can also come to NCLT, and other people can also come to NCLT. Other people can also come to NCLT, ma'am. What is that actually happening? See, maybe I am just the creditor of the company, or maybe I'm just one person of the company who has been supplying a lot of goods to the company but not receiving any payment, or the company has been taking a lot of advance from a lot of people but not supplying goods. So we are the ones who suspect that there is some fraud going on in this particular company. But where do we go? We want this fraud to be investigated because we can't do that. We have no option to go to central government, right? Because we are not the members. If we convince the members and somehow the members pass SR, then maybe we can go to central government. This inspection inquiry has not happened, and maybe in public interest government, it's very hard to convince, right? So we can't go to actually central government. So we can go to NCLT. Any person can make an application to NCLT. You just have to provide that evidence, and if NCLT is satisfied of these things, NCLT, after giving a reasonable opportunity of being heard to the company and the parties both, they will decide about investigation. And in that situation, CG has to carry out the investigation. Okay, so these members, along with supporting documents and reasons, you may send an application to NCLT, or any person make an application to NCLT or NCLT suo motu if satisfied of these things, any of these things, that maybe the business is being conducted to defraud its creditors or members or any other person. Like I told you the example, the company has been continuously taking advance from a lot of people by saying that we will supply you the goods but never actually supplying the goods, right? So in that situation, well, the company's intent is clear. It's trying to defraud us. It will one day run away with our money. It does not have the intention to supply the goods. Secondly, the company is actually formed for fraudulent or unlawful purpose. That means maybe there is some trafficking, or it is just a shell company. It has not been formed for a proper lawful purpose. Okay. Maybe it is working in a manner oppressive to members, that we read in the chapter of oppression. Okay, maybe the persons who are involved in management and formation, that is management and promoter, they are involved in fraud or misconduct or misfeasance. Misfeasance is negligence, misconduct is not properly behaving, not exactly the behavior but also your other things, and fraud is intentional or deliberate. Malified intention, you can say, right? Then members have been given incomplete information about the commission paid to MD, director or manager. The remuneration that you pay, you have stated, but other than that, you're also maybe paying some commission and all that, linked incentives. That information you're not giving to the members. So if NCLT is satisfied of these things, then NCLT can do that, and then CG, you are bound to carry out the investigation. For that, you will be appointing the inspector who is going to report to CG. Fine. Okay, then we come to section 212 where we talk about investigation into affairs by SFIO. So maybe on receipt of report under section 208, CG finds that, oh my god, this is a serious fraud case. Maybe on receipt of SR, maybe in public interest or request from Department of CG or SG. If central government considers that yes, SFIO is necessary, they will assign the investigation to SFIO. When SFIO steps in, everyone steps out. So no other investigating agency, maybe the crime was also being investigated by some police authorities, maybe income tax department was doing something, right? They will also stop. Everyone is going to stop because SFIU is a multidisciplinary organization in India which comes under Ministry of Corporate Affairs, where you have the experts from every field, multidiscipline, right? So it's not just that, okay, in income tax department, if they're investigating, if they are thinking about or scrutinizing any case, they have probably one field people. They can only look from the tax evasion perspective and not other ways. But when I'm talking about SFIU, you are dealing and trying to detect and prosecute those white collar crimes. So you have people from the field of accountancy, forensic, auditing, law. You may also have some people from money laundering, right? All that, they can detect things, right? So if SFIO steps in, then everyone stops. If they're already investigating or it has been initiated, then they will stop and transfer all the records and documents to SFIO. So once the case is assigned to SFIO, in these cases, what will SFIO do? SFIO, you will just check that whoever is the appropriate investigating officer under you, then you will appoint those and they will carry out the investigation in the same manner. They have the same powers as the inspectors have under section 217. Everyone will give them assistance, and they also have the power to arrest under section 2126. Fine, you don't need to read all this in detail. I've already told you what exactly you need to read and what you don't need to read. Okay, thereafter, once the investigation is complete, you will submit the report to central government, and if the report talks about fraud or anything, any prosecution, anything, then central government may direct SFIO that you initiate the prosecution. Prosecution, there are students who are often confused about this term prosecution. It only means the court trial starts. If there is a crime which has happened, if there is a murder which has happened, do you think the police will catch somebody and then send him to the jail? No, that does not happen. So police basically prepares a report and then the case is being filed. The charge sheet you file, that is in the common language that you know, right? So that is being filed, and thereafter the court trial starts, where you can defend yourself and ultimately the court punishes, right? In the same way, SFIO, you are investigating, you'll prepare a report where you will tell about that this particular person is suspect and all that, guilty. Against that particular person, the prosecution starts. That means the court trial starts. Okay. And ultimately the court is going to, the investigation report is filed here is under the special court for framing charges. Okay. Now, next we have section 216 where we talk about the investigation into ownership of company. So far we have spoken about affairs, but many a times people hide behind the mask of their relatives. Like if I have a company, I may not be the director or member of that company, my relatives are. So ideally it doesn't look like my company, but all the decisions I am taking. So I am the one who has actually invested in the company. I have given money to them from indirect sources and they have invested my money only. So I am the one who's financially interested in the company. I am the one who is actually controlling this particular company, and I am the beneficial owner of shares. Shares might not be in my name, but I am the beneficial owner. I hope you understand the concept of section 89 and 90 that we have read about, beneficial ownership and significant beneficial ownership. So many a times it happens that when we look at companies' register of shareholders, we may not find Mr. X's name, but he is the beneficial owner. The shares are in the name of some friend of his, but he's actually the beneficial owner. So ideally under section 89 and 90, you need to report and give the details that yes, you are the beneficial owner and all of that. But when you have not, through this section, we can find out the hidden beneficial owners. So who are the real who are really financially interested in the company, who are the real controllers, and who are the hidden beneficiaries, government intends to find out that through the investigation. So, if there is any complaint any person has done or reference by NCLT or CMO to central government may order the investigation into membership to determine these people. For this, again, CG will appoint the inspector who will investigate into the matters relating to company and membership and will finally give a report to central government. Okay, clear? Now, many a times it also happens that there is no formal understanding between two people with respect to the beneficial ownership or something like that. There is an informal understanding. So that can also be investigated. Undoubtedly, when the people are trying to hide their ownership, there will be informal understandings only. Fine. Okay. Next, we move to section 219, where we talk about investigation of related companies or related entities. See, um, if the crimes are happening, or you must have heard, in fact we also discussed something about Satyam scam, right? So basically what happened, people were trying to inflate the revenues by generating fake invoices. Now, supposedly, there's a company, ABC Limited, everything clean, all records clean, and ABC Limited has invested a good chunk in the shares of PQR Limited. So, almost the entire money in PQR Limited has been transferred from ABC Limited only in the form of shares, right? Now, in that company, they're trying to generate all the fake profits and window dressing, manipulating the accounts, this and that, right? And ultimately, they will pass on that benefit to the people who are involved and ultimately show that, okay, there were losses and this is round and etc. etc. So, a lot of manipulation can take place basically. What I am trying to tell you over here is that sometimes the fraud does not happen directly in the company, but the company does it through its people, through its entities, maybe through its subsidiary, maybe through the MD. So, by checking at the bank accounts of MD, we get to know certain frauds. It may so happen by any employee, through any employee or manager, right? Or uh, when they are not direct holding or subsidiary, it may so happen that Mr. X, you are the managing director of A Limited also, and you are also the managing director of B Limited, right? So somehow you're doing this, or you have done some fraud through this. Maybe you are involved, or maybe the company is involved, whatever it is. So sometimes it may so happen that we are investigating because CG has told us, SFIO is investigating, or investigation is done by CG on request or on order of NCLT. Okay. During this investigator, whether it's the inspector or the investigating officer of SFIO, during this investigation, they consider it necessary that I also need to check the details of these related entities. They may. But after they take the approval of CG, after they take the approval of CG, then they may. So, whose accounts? Subsidiary holding, subsidiary of holding, MD, manager, employee, body corporate which is being managed by MD or manager, body corporate whose board includes nominees, and body corporate whose board acts according to the direction of the director. Okay, so they may do so. Next we have section 220, which is seizure of documents by inspector. Exactly what we have read about search and seizure in section 209. So that we read during inspection and inquiry. This is during investigation. So during investigation, if the investigating officer has reasonable grounds to believe that books may be mutilated, altered, falsified, then they may enter and seize and return after completion of investigation. Fine. Now, inspector, after you have completed the investigation, you are going to submit the report. That's going to be a final report. And if you are also required by CG, then you also have to submit an interim report. Okay. The report, copy of the report can be obtained by making an application to central government, and the report has to be authenticated either by the seal of the company or by the certificate of public officer in whosoever custody the report is. Okay, fine. Now, once the report is submitted to central government, you may take certain actions. Certain actions. What are the actions which central government may take? First one is prosecution. Prosecution means what? After the report, we came to the conclusion that, okay, Mr. X, who is a director of the company, has done some fraud and is criminally liable. So there will be court trial which will start against him, and everyone has to give that cooperation. Okay, that may happen. Secondly, there may be winding up. Winding up, why? Because once the report has been concluded, we get to know that there is nothing left in the company, and all the people who are involved, they are involved in some mismanagement, right? So this company cannot actually function properly for the benefit of anyone. So the company, now you don't know the provisions of winding up yet. We have a chapter under Companies Act which talks about winding up, but more importantly, the major chunk in the provisions of winding up have been shifted to IBC after it came, Insolvency and Bankruptcy Code, right? So maybe the company is liable to be wound up under the winding up, or under IBC, right? Or maybe the company is not entering into winding up. That means investigation is going on. Maybe the company itself has passed or is willing or voluntarily going for winding up. Fine, then winding up can happen. But supposedly investigation is going on, there was no winding up which was taking place, the company was functioning as it was supposed to, but based on the report, CG discovered that no winding up should be done. That is how this company should be treated. So now central government can't just wind up the company. There's a procedure. So you have to make a petition to NCLT, and thereafter winding up shall take place. Likewise, we also have an application of under section 241, which we'll be reading in the chapter of oppression. Okay. So that can also be done. That can also be done. Next is the recovery of damages or property. The recovery of damages or property. There is any director or there is any employee, maybe they have taken the property of some company, not particularly this company, or maybe of some other company wrongfully, right? Or they have misapplied the property of the company. That is, there is the machinery, maybe that particular person has taken that machinery of the company, maybe they have done some embezzlement, maybe they have done some fraud, maybe whatever. So recovery of that damages, recovery of that property due to their negligence, there is a loss which the company has suffered, so that is being recovered. That can also happen. Next is this is disgorgement. What is disgorgement? Disgorgement is the recovery. Ma'am, recovery here also we are doing, but this is the recovery of undue, or I should say illegal gain. Illegal gain. Like the company had to sell the goods of 25 CR. The company or one of the director has actually sold these goods for 30 CR and made an illegal profit of 5 CR. So this is not a punishment, this is not a compensation, these are not damages, etc. But this is an illegal gain which they have done, and we now want to recover that. We now want to recover that. So central government can also pass an order for this. So if there is a report of inspector which states that yes, the fraud has taken place, and maybe there is some KMP, some officer, some director who has taken undue advantage of that situation and has taken some benefit, that recovery of benefit is called as actually disgorgement and can also be held personally liable. Fine. So when central government gets the report, these are the different actions which may be taken. That is, first is prosecution, second is petition for winding up or oppression, third is recovery of damages or property, fourth is disgorgement. Fine. Now, central government, you will be indemnified for the cost of investigation that we'll be reading separately in a section called as section 225. Next, we have powers of inspector. Only individuals can be the inspector. I hope you know that. Next, we have the powers of inspector, the procedure. It is exactly the same that we have read before in inspection and inquiry. So, during investigation, everyone, you have the power to call for information, and past or present officers have to preserve and produce the books plus provide you all the assistance. You also have the power to seize the books and keep in your custody for maximum 180 days. You also have the power to examine people on oath. You will have the same powers as of a civil court in respect of certain matters, that is discovery or production of books, summoning and enforcing of attendance, and inspection of books and documents. Fine. So for these three matters, you will have the powers as of civil court. The officers, police authorities, everyone will provide you assistance subject to your take CG's approval. This reciprocal agreements you can avoid, and that is it. Okay. Next, we have protection of employees. Protection of employees, section 218. Now, during investigation, many of the employees or officers might not want to cooperate with the investigation. Why? Because they're scared that if I tell something, if I provide a document, if I tell some truth, then I may be demoted, I may be suspended, I may be removed, right? Or my salary may be reduced, or I may be treated indifferently or badly. So, this particular section actually provides them protection. So, when the investigation is going on during this particular sections, or maybe there is some proceedings which are going on during this period, if you want to, if the company or any body corporate wants to, who is involved undoubtedly, wants to discharge or suspend the employee, you want to punish him by demoting, by reducing his salary, by changing the terms of employment to his disadvantage, etc., etc., then you can do this only after you obtain the approval of NCLT. Now, you have applied for the approval. The NCLT will not give you the approval instantly. They will actually send it by post. Now, we are waiting. If they do not reply within 30 days, we can proceed and take action against the employee, because sometimes the employees, we genuinely want to remove this particular employee because he's not working properly, but because the investigation is going on, we have been instructed that during the proceedings of investigation, you cannot actually suspend, discharge, punish any employee except with the approval of NCLT. So we need to take the approval of NCLT. Now, maybe sometimes the employee is not satisfied, maybe sometimes we are not satisfied with the order. So appeal can be made to NCLAT. Okay, within 30 days. That's it. We also have a section called as section 225, the expenses of investigation. So expenses prima facie or at the first place will be defrayed by CG. Later on, it can be recovered by certain people. Point number one, whoever has been prosecuted. So you are the one who has been prosecuted. Okay. Secondly, it can be reimbursed by somebody who has been asked to pay damages or restore property because you took so. Okay. Somebody who has whose name has been got, like maybe there is a company of whose some property has been recovered, so that particular person can also be asked to reimburse. And if there is no prosecution that has happened, so whichever company, body corporate, MD, manager was dealt in the report of inspector, or the applicants who had insisted on the investigation, they will actually reimburse. So this is just to ensure, because CG is not going to bear the cost of investigation. Like, I am somebody who said that some fraud is going on in this company, and I tried to provide certain documents and I requested NCLT. NCLT passed the order of investigation. Thereafter, CG had to carry out the investigation. Okay, CG carried out the investigation, and at the end result was that there is nobody who's involved in any fraud. Nobody it did not end up in prosecution of anyone. So no prosecution was instituted. Right now, what will happen? This entire cost of investigation, who's going to bear that? The applicants. The applicants and whoever company MD was involved. Okay, we are going to bear that. In fact, when we submit an application, CG sometimes ask her, before even appointing the inspector, they may ask us to give us a security amount up to 25,000 to cover this cost, because later you might deny, later you might not, and the recovery is difficult. Okay, so that is how expenses of investigation are met. Fine. Okay.